Welcome to both Slow News Day Live and the Free Assange Vigil. We are coming at you with some breaking news. As you know, um, Julian Assange appeared in court today with his legal team to determine whether or not he would be granted bail in the middle of a global pandemic. I am joined well, I guess this morning for me, but this evening for him. I am joined by Muhammad Al Mazi. He's a internationally renowned man of mystery and wonderful writer. He was in the courtroom today, so we're going to be able to have a firsthand, first person perspective of this with no further delay. Mo, how are you? How's it going?
I'm I'm fine. Thank you very much. Thank you for having me. Yeah, it was interesting. My first day out following the lockdown ordered by the Prime Minister. So it's an uncanny sort of experience.
And oh, that's right, because you can't gather with more than two people. You can't do yeah, you basically can't do anything. You're under complete and total lockdown. You have to have it.
Sure. So there are four. Go ahead.
No, go ahead.
Oh, okay, sorry. There are four exceptions, which is if you need to go to and from work, and only people who can't do their work from home are supposed to go. And of course, this was happening in court, so I went down to court. If you're going to provide somebody with care or medical care or to receive medical care, if you're going to pick up food or other like basic necessities like medicine, and if you're going to do your one exercise, you're entitled to like one exercise type thing a day. I can't remember if they explicitly say ideally for an hour, but with no more than with only with people. If you do it with people, only people that you're living with. Otherwise, they're saying, yeah, stay at home. Don't visit friends. Don't visit family. Um, Stay at home to allow the opportunity for as much as possible for the virus to die off or to be contained, and also for the preparations within the health service to be made as they're trying to beef up the health service, which in this country has been sort of undermined via privatization for many years. Um, so yeah, so that's basically the picture. And there's also the proximity thing: stay, 2 meters away from people. Uh, um, if you touch things, try to wear gloves. Don't touch your face or wash your hands after you touch things. And so, yeah, it was interesting in court where they did their best to sort of implement this, going through security. The person with the wand was standing 2 meters away, which was interesting. So, yeah, just on a
How does
practical level.
real I don't
Yeah,
mean
yeah.
to interrupt, but how does a security sweep with a wand work when you're 2 meters away? Like, is he
Uh,
leaning into it? Is it
there
that
is a degree
cartoonish?
of leaning, and I think they can increase the sensitivity of the wands. I think they have sensitivity settings. Yeah, I mean, I just have to assume that that's how it because he was and it takes some getting used to because like I said, this is my first time out, so there are lots of things that I keep forgetting about the 2 meter distance thing. Yeah, of keeping 2 meters as much as possible. I think it was at 6 feet they say. But yeah, there are only a few of us in court. And just one slight correction: Julian Assange appeared via video link. He did not appear in person. Belmarsh Prison is a couple of hours away from Westminster Magistrates Court, and that's where this particular hearing was held. Although the next hearing for the 7th of April will be held next door to him, literally next door to the prison where he's being held in Belmarsh Magistrates Court.
And that's a case management hearing, correct?
That's true. That's a case management hearing, and according to the current schedule, that will be the final hearing before the substantive extradition hearings restart on the 18th of May. Although, given everything that's happened, it may be the case that date is vacated. That was strongly suggested by the defense lawyer actually today. That it's highly unlikely that things will continue as scheduled, especially since actually prison visitation has now been closed off as of yesterday, the 24th of March, following four separate prisoners being confirmed to have COVID-19 in 4 separate prisons. Um, so all visitation now is temporarily suspended, suspended till further notice, and that includes lawyers meeting with their clients.
That I have so many problems with this on so many different levels. It so at least in the US, unless you've got special permission to be in the same room physically with someone, almost all visitation is done through like a 3-inch thick plexiglass wall.
Mhm.
You can't even have direct contact with an inmate. You are basically at all times by yourself when you go into the hallway to go to the visitation room. Like, this is something that can be done, and you can still allow families of prisoners some semblance of contact, at least here. I don't know how it is in the UK. Um, but you can at least still have some semblance of contact without violating any of these protocols for the coronavirus. Eh,
I've never been to Belmarsh prison. So I used to work in law before I joined, came into journalism. I've never been to Belmarsh prison, but I have visited clients in other prisons. And when we met clients, we were in separate rooms, like me, counsel, sitting in a room that was just me, counsel, and the prisoner and client with the door closed. So I don't know how things are set up. You know, if I know they don't have, for example, there are like 100 staff apparently from Belmarsh who are isolating apparently prison, right? So we don't know if that is because they suspect they have symptoms or it's preemptive. Um, but there's also the issue of, I think there's also the issue of facilitating it. But yeah, no, not all of this is done via plexiglass. Um, and also you need to have, I think there's also the issue of fewer and fewer people going to work. So if you have fewer staff, then there's fewer people to facilitate visits. Also, I don't know if you're aware, but there have already been complaints going for months now of just poor access with Julian Assange and his clients, well before this COVID thing became an issue, even before it was, blew up on the world stage, where they were making complaints to the judge saying prison authorities are denying us proper access. So it's already a sort of system that is, let's say, not exactly conducive to proper time spent with between incarcerated and family, or incarcerated and their lawyers. So you can imagine that part of it will be a resource issue. But yeah, actually, from the perspective of just the spread of the illness, all the medical reports, all of them say, including a report I recently saw from and reported on from the World Health Organization, say that prisoners are especially at risk, that these places are practically like reservoirs of illness, that they are often sites where illnesses not only spread rapidly, but make their way to the rest of society, right? It's because of the high concentration of prisoners within, and in fact, this goes to some of the arguments being made, by the way, in favor of Julian Assange's emergency bail application. So perhaps I should just go straight to it, and I can sort of list the types of things they discussed.
Yeah, let's do that, and then we can also talk about what the court had to say about it and why
Yeah.
that's bullshit.
Okay, so so there are 3 sets of main speakers. Edward Fitzgerald was the only lawyer present. He's the barrister speaking there on behalf of Julian Assange. Everybody else was there via, so the other lawyers and even some journalists were there via telephone conference. And that includes the prosecution, Claire Dobbin, who is speaking on behalf of the US government. So it's important to understand that the US government is the other party being represented in court, not, say, the British government or the Crown Prosecution Service. And the US government was there opposing his release. They spoke first. Their main arguments were, and I just, maybe I can get a quote correctly. It's not for any court to preempt any decision which the Ministry of Justice may make in this respect. Um, So she said, according to the Bail Act 1976, the arrangement of protection for those in prison is up to the Ministry of Justice, not a judge. She also noted that it's been widely reported that the government may start releasing people on temporary license after risk assessments have been done. So she's saying this is up for the Ministry of Justice to do, and really it's not for you to preempt what the Ministry of Justice will do. She also told the court that argued that the health of an individual won't be relevant to the risk of a defendant absconding while on bail. That's a quote. She said, to continue, we say that on behalf of the United States, there are substantial grounds for believing that Mr. Assange, if on bail, would abscond, would commit other offenses, or would otherwise obstruct the course of justice. He's already indicated that he's willing to go to almost any lengths to avoid being extradited to the United States. We say that the risk of flight is insurmountable, she argued. So you get the idea of her main arguments. This is the lawyer representing the United States government. She spoke first via a telephone link, as I said. She also then specifically dealt with the fact that, hey, look, there was another extradition case towards Sweden, and there was surety guarantees that were made, and people who spoke on his behalf, and arguments that were said that he wouldn't want to reduce the image and the reputation of WikiLeaks, not only himself in front of his supporters, that he's a man of honor, that £100,000 was put up, etc., as collateral, and then in the end he absconded, right? And then he absconded to the embassy. This is what she argued.
Okay.
And this is quite important because the judge ended up referring quite strongly as well to this case. So this, by the way, I think if people wonder why it is that the lawyers never made previous bail applications, you have to understand the thinking and mentality of judges here, and possibly in other countries as well, possibly in the United States, that if you have somebody whose conviction, to be fair, his only conviction in any case, but nonetheless, who's convicted of absconding while on bail, also in terms of an extradition case, where it was argued that the reason he did this was because he feared extradition to the United States, you can understand why they wanted perhaps to wait until they had a strong enough legal footing to be able to present a bail application, because you don't want to just make an application that'll be rejected and not really have good grounds to appeal, because you can run out, if you like, you can have too many bites of the apple. So you have to be strategic with the applications. And that was the main argument of the other side. So what I already said, along with the fact that, look, he was on bail before and he violated bail, so you can't trust him, right? If anything, he said this is about extradition to the United States. Well, the reason he violated bail before is because he said he feared extradition to the United States. So that's their argument, right? Then Fitzgerald comes along. He says, look, this was historic. The factors that were in play 8 years ago aren't in play now. His father will be based here. In fact, his father comes back and forth between Australia, spends like half his time here. Also, his partner with children will be based here. In fact, his partner's identity was not revealed. There was a push for her name to be made anonymous, to be anonymized. The judge didn't agree, but she did agree that there would be a reporting restriction, at least until 7th of April, and then it'll be up to the press to argue why the anonymity should be pulled. Press did try to argue today that it was pulled, not me, but one of my colleagues at Press Association did try to argue that it's in the interests of the public to know what his partner's name is, but there's also concern about the children being harassed, etc., because of the media frenzy. So, but that's a side issue, really. So she submitted her own witness statement saying, look, it's me, his children, we're going to be based in this house. It's separate, it's not close to London. So it's not like there's an embassy that he'll be close to that he'll run by. There'll be all kinds of conditions, ankle bracelets, etc., that can be done. Fitzgerald also argued that, look, we have, people who are alleged to be violent terrorists who are kept in custody outside of prison, right? So there are means and measures whereby if we can do this with people who are suspected of being incredibly violent, dangerous terrorists, then we can do it with somebody who's not accused of any kind of violent offense, right? And then there's also the health aspect. He presented three witness statements from doctors, three reports from doctors, two of which have have examined Julian Assange on multiple occasions. They said while technically Assange doesn't fall into the category of vulnerable groups as currently defined by the government, which is defined comes from NHS, comes from Public Health England, right, the Public Health Department. They said, first of all, that is being adapted over time in terms of who falls into the vulnerable category. And also he's had four separate respiratory tract infections just while in the embassy. He's had infections with his tooth that wasn't dealt with. He has early onset osteoporosis. He has depression, which also means weakened immune system, all this time of isolation. So they said that they do believe, nonetheless, that he is in a vulnerable state. There's a very high likelihood of him getting infected because he's a prisoner, like all other prisoners. And
Yeah.
that seems to be the generally accepted position, by the way, that including from the president of Prison Governors Association, they said it's almost guaranteed that prisoners are going to start dying because of the level of concentration of prisoners, as well as the unhygienic, overcrowded conditions that they're in. But they also said that he, like everyone else, is at high risk of infection, but he's also, they consider him to be in a vulnerable category. So that was a key part of the argument. There was also the legal preparation argument. They said, we don't think, quite frankly, that the hearing is going to be able to go ahead on the 18th of May. But even if it is, and even if it's not, he needs to prepare. And we're already having difficulties preparing under normal conditions. I already mentioned the fact that the lawyers aren't getting proper access. He's not getting proper access to his case file, right, etc. And that's been going on for months. But also, we can't visit our client now. And there's video link option, but there's a queue for that. And right now, the queue, we won't be able to speak to him till next week. Like, there's a queue because there's other prisoners who want to access video link, right?
Yeah.
It's not like
Well,
there's
and they've
50
got,
video
I'm
link
sorry to interrupt, but they've got to know that that's not a secure video link. There's no lawyer client confidentiality over that video link.
Well, that wasn't mentioned. I would imagine that if that was said to the judge, they'd probably argue that it is that this kind of video link would the government can be trusted not to listen in to, which would be ironic, of course, given the fact that the government, we know for a fact, was spying on him, lawyer client conversations while they're in the embassy. But anyway, that's a separate issue. But so to be fair, an interesting point actually, and I discussed this with the lawyer after the hearing was over. She never addressed that particular point, by the way, in her judgment. But just to finish off those arguments before I come to her judgment, which was so we can't properly prepare for the case. How can we do this when it's like when there's a massive queue and it's got to be done via video link, right? So that means, we have even less access to our client than we normally did, which was insufficient before. He's at high risk of infection. He's now looking at 23 hours or more of isolation, which exacerbates his mental state, his depression, right? We already had a report from three separate medical professionals saying that Julian Assange shows the symptoms of being psychologically tortured, and part of that is extreme isolation, right? Part of the contributing factor.
Yeah.
We're looking at now 23 hours or more of isolation now because of the lockdown, with only 40 minutes, with only a brief 30 minutes exercise in a small yard with 40 other prisoners, right? Which, given COVID-19 is all about transmitting a high risk of transmission when you're in close contact. On the one hand, he suffers, like other people, perhaps, from extreme isolation now, more isolation because of lockdown, which exacerbates his mental health. On the other hand, what little access he's got when he's not in his cell will be with 40 other people in a very small area, right? So it's like, and also queuing up. He said queuing up for the video link, you can see there's all kind of chances of getting contaminated. So
Yeah.
it's like, and it's not just to be clear, it's not just good lawyering, say, from the defense side. Like I said, there have been multiple reports I've read that have been published over the last week or two, which made very clear that prisons are massive incubators for contagious illnesses. Iran, for example, has released over 70,000 prisoners. 70,000. You can't imagine that Iran would be doing that for no reason, right? They're
And
doing it
Iran did
because of,
that
yeah.
2 weeks ago.
Yeah, yeah,
at least a week and a half ago. I
yeah,
read the
exactly.
number is 85,000. It could be lower, but the point that I made was, according to the West, Iran is this brutal theocratic regime that has
Yeah.
no value for the lives of their own citizens, but they can release tens of thousands of prisoners, and Julian Assange still languishes in Belmarsh.
Yes, exactly, and so the point is that it is recognized that like prisons that any that's why the social distancing rules are in effect for all of us. The 2 meters, no more than two people in a group. It is precisely on that basis to reduce to as much as possible reduce the spread of the illness while all kinds of measures can be taken in terms of beefing up the healthcare system as well as working towards a vaccine. So these are the main arguments posed, right? That you can take more severe conditions to ensure that he doesn't abscond. You know, the kinds of things that you would do. Think about the kinds of things you do for somebody accused of serious terrorism offenses, but who isn't imprisoned, because that is done. House arrest, all kinds of house arrest. Um, there's the health. There's the legal preparation, also 12 guarantors. So they found guarantors and all the rest of it. So then the judge comes with her decision. Her decision was to refuse the application. She didn't address any of the parts in terms of violation of his right to due process or his access to lawyers. She didn't mention that in the statement. I should also mention right now that her statement was made pretty much immediately, so it was prepared. So obviously she'll have had some of the arguments in advance, right?
Mm.
It's not like she wouldn't have heard any of the arguments. Some of it would have been sent to her in advance to prepare, because that is normal here. Where
Yeah.
even though you have an oral hearing, legal submissions are made previously. But the point is, the arguments were made, and then as soon as the arguments were done, and it was clear that everyone had finished, he'd finished his summation. She took a breath and then started to read from a prepared statement. So she had already, it's clear to me at least, she'd already made a decision on the papers. I suppose arguably she might say, well, I could have been convinced otherwise orally and then changed my mind, right? So I made the decision on the papers on the basis that, I've made my decision, but I'll let people come up to their own decision about that. She outlined the brief history of the case, noting that he'd previously absconded from bail. She considered that to be quite significant. That was key to her decision. In terms of the healthcare aspect, she said, well, she notes that the three doctors disagree with aspects of the government's guidelines. Yeah, but she said, the government is being guided by scientific advice, data-driven advice from Public Health England. And I'm sure with all these people who are working, 1,000+ people in Public Health England working on a science-based approach, are providing the best possible rational advice for the government, and the government will base its decision on what to do with prisoners based on what they're being told. And I have no reason to consider that they will do anything other than what is in the best interests of the prisoners, right? So that was a key part of what she'd said, if you like.
Does anybody
Another
buy that, by the way? Like, is that an acceptable answer to anyone sitting in that gallery?
Well, I mean, people can't exactly shout out or anything, right? So you
Fair enough.
listen to the arguments and then you just go from there. She said, quote, "It's the government's responsibility to protect both the vulnerable and those outside the category. And I have no reason to doubt that Public Health England will provide the appropriate advice to the government to ensure the health and well-being of the prison population." She also then says later on, um, after a warrant was issued for his arrest, he remained unlawfully at large for many years, and he has every reason to try and abscond again. There's substantial grounds to believe if I released him today, he will not return to face his extradition hearing. There are no conditions that could allay this concern, and this application for bail is therefore refused. Right? So that was the long and the short of it is he has a history of absconding. Um, in terms of his health, okay, fine. The doctors say that they have concerns, but he isn't technically in that category. He doesn't have one of those illnesses that makes him specifically in that category of higher risk. She notes the fact that the doctors sort of disagree perhaps with the government guidelines, but okay, those are the government guidelines, which will be updated. She also noted the fact that the government is looking at releasing possibly some prisoners, and that will be decided in due course, because that was said at the beginning, right, by the U.S. government representative. And she also said that, quite frankly, I don't think that if he's released, that he will come to court. I think that he is, he himself has said, as we've seen in defense statements, that he would rather commit suicide than be deported to the United States, and that shows that he will go to any measures to avoid, and I think that would include absconding. Um, and so, for the reasons that I think that his health will be taken care of, and the fact that he will abscond because he has a past history of doing it, and I'm not convinced that there's any conditionality that he can be subjected to that would prevent him from absconding. So I'm refusing the application, and that was essentially that. Although I did say that the lawyer told me that they will appeal.
So
No, he said we will likely appeal. That's what he told me. He said we will likely be appealing
let
after the
me
hearing is over.
let me ask this then, because the UK warrant for him absconding from bail wasn't issued until a week to 10 days after he had already been granted asylum, which
Yeah.
makes the warrant itself false on its face and inapplicable. Has his legal team brought that up at all?
Well, no, because they can issue it whenever they want, right? There'll just be a statute of limitations, which could be, I don't know what that is. Could be like a year. I mean, unless it's a common law offense, because common law offenses have no statute of limitations, unless one has been later on prescribed into law by Parliament. So it's because she also noted that because when he went into the embassy, technically he violated the bail conditions, right? Because there are conditions, which is you've got to report to the police every day. You've got to present yourself. Well, and also there was the court judgment, which said that you've got to present yourself to police to be prepared to be extradited. When he lost at the Supreme Court, when the Supreme Court refused to hear his appeal for the bail to be reopened, in terms of the Swedish case. So that in of itself was a technical violation of his bail conditions, right? So she's saying he had an ankle bracelet, right? He had people who put up money. He had people who spoke on his behalf, you know, um, and he was granted bail, and the bail was challenged, and the government appealed, and it went up to the High Court, and the High Court affirmed his right to bail, and he went out, and then he violated it. Now the Fitzgerald was like, okay, that's true, he violated it, but to be clear, he didn't violate it by like running off into dungeons somewhere. He went and claimed his right under international law for diplomatic asylum. And okay, that ran contrary to English law, for which he was then arrested and convicted, and he's spent his 50 weeks in prison, right? So that was his argument, and he did try to say, like, look, before he didn't have his whole family here, his whole family will be here, or his key members of his family. So he did try his best to distinguish the facts, and he's saying, like, look, if we can keep terrorists, people who we say are going to blow people up, out of prison, but in house arrest of some form, then we can do it here, especially under the COVID. But her ultimately she was not persuaded. Um, and yeah, so in terms of that argument, I don't think that that would be a legal argument that they could pose. When he did violate his bail conditions when he went into the embassy. The there were multiple things he had to do, and he stopped doing them once he went into the embassy. And it's up to the government to decide when, if they want to issue like an arrest warrant. That makes sense. You know what I mean? They could be consulting. They don't have to issue it like on the day that he went into the embassy.
Right.
But there would be no point in raising that, because the point was he was found guilty in an English court, and you know what I mean. And she accepts that conviction. As far as she's concerned, that conviction is legitimate. So you always have to pick your battles as well with judges. You have to know which arguments will work and which arguments won't work. It will be interesting to see how it goes on appeal, though, right?
Well,
Because this is yeah, go ahead.
can it seems like Barrister, whatever her name is,
I
uh,
believe so. Yeah.
the entire magistrate's court um, has a clear, demonstrable bias against both Julian and his legal team. And it's almost unfathomable to me that the legal team itself isn't making the argument in the press, at least, so that they can get the court of public opinion on their side, that this court is literally stacked against their client. And why aren't these people being removed?
I think so. I don't know what it would be like in the United States. Over here, you would genuinely risk the wrath of the court if you do that. You also risk contempt, violating the Contempt of Court Act if you do that. So here, even if I were to write something, I could cross the line in terms of if I write something about the judge, if I write saying, "Oh, she's like a biased hack and there have been people who've written that, but like you're at risk of violating Contempt of Court Act if you do that. So, and if you're you have to understand if you're a lawyer, you risk your license. It's not you don't do your. It's better to leave it for the non-lawyers to make those arguments. If lawyers start doing that, they undermine themselves not only with the trial lawyer they're dealing with. I mean, technically this isn't a trial, but you know what I mean. With the main lawyer who's presiding over their case, but also with other lawyers, and I guarantee other judges, and I guarantee you they will not appreciate it. That includes appeal judges that you're going to be dealing with in the future when you start appealing either the final decision or other aspects of the case, like the bail hearing. This is a close knit group. You know what I mean? You
Yeah,
start, if
yeah,
you go against one of the judges, um, it might make you feel better as a lawyer, but it won't help your client. In fact, it'll almost certainly hurt your client. It'll hurt them if you get kicked off the case because you're then fighting something at the bar, fighting a suspension at the bar if you're denied. You know what I mean? Because they can, there's wide discretion in the end if a lawyer crosses the line. It's one of the ways that lawyers are kept in line is the fact that there are rules about your conduct both inside and outside of court. I know because of the First Amendment, there are lots of things that people are allowed to say, for example. Um, but here it's quite normal for example, for there to be reporting restrictions. So not only are there things you have to be careful about how you report about the judge, but if it's a jury trial, you're not allowed to report anything that will be presented to the jury, but that the jury haven't heard yet. You can only report about what the jury heard. So if I know that a witness is going to testify tomorrow that will say that this person, Jerry Epstein, did this to me as well. If I put that in an article before the jury hears that, I could go to prison. People have been prosecuted in this country. And
yeah.
I know it's a bit different from what you're saying, referring to, but I'm just trying to say that there are different sets of sort of rules in terms of how people can behave and what people can say outside of court when you have ongoing legal proceedings.
Yeah, no,
And
I know that when media discusses an ongoing case here, they have to couch it very, very specifically when they report on it. And there's certain phrases that everything has that have to precede,
yeah,
every sort of declarative sentence. You've got to either couch it as a hypothetical, or you have to couch it in terms of we already know from the court that XYZ has happened, therefore we can speculate on ABC, but
yeah,
that's it, there is a tap dance that has to take place, um, unless unless you're a small outlet or an outlet that has already had its credibility dragged through the mud by the mainstream, and then at that point you have a little bit more freedom to be like, this fucking bitch right here is bought, Um, to be perfectly honest, there are so many things that you can be shut down for as an independent outlet here that you might as well just flop it on the table and see what happens. Like I mean, in terms of what I do at Slow News Day and what we're doing on the action on the Free Assange Vigil series, like we've already stuck our necks out before we even go live. It's right there in the title, it's right there in the name of the organization. Um, so we're going to scream about it, whether it's speculative or or already demonstrably proven fact. We're going to scream about it. I do appreciate the straight reporting on this because a lot of people get lost in the legal argy-bargy, and it's nice to have someone with a legal background like yourself present it in layman's terms. I appreciate the hell out of that.
Oh, thanks. Yeah, sometimes I have to remind myself though, because it can be to do that, because my first drafts of things can often be just because it's natural for me to understand like the legal jargon to be, and also for whatever reason, when you spent years in it, there's part of me that's still sort of attracted to it. So I just have to remember that, somebody else will look at that and it just won't mean anything. So you just have to, sometimes I there's a balance between wanting to give as much detail as possible and then realizing that if it's too detailed and too long, just very few people will read it. And that I because I never want to give people the wrong sense about what happened. You know what I mean? I don't want to give them an unbalanced sense of what happened so that they can generally understand what was said. But at the same time, people don't need the 3 hours, almost 3 hour long hearing, by the way. So
Yeah,
people don't need the 3 hours. They just need, I think, the main arguments. They don't need to know that the in depth that there's this one court precedent that was cited where a judge decided this. I think the main thing is just to hear the main sides of the argument, which is he did it before, he'll do it again. Sure, he did it before, but he won't do it again. And his health and well being is paramount. That was the other thing. She didn't address human rights grounds, but I suppose she would argue she'd address that by saying that the health and well-being is being will be looked after by the government. The one thing I would point out is that, well, the government has already been called out on failing to investigate his apparent torture by the UN Special Rapporteur on Torture.
yeah,
And she was also told that there were already two suicides in Belmarsh just this year, right? So
yeah,
and there have been, I've only been at Sputnik reporting, for example, since November last year. So it's only been like 4 or 5 months now, right? And I've already done like four separate articles on four separate reports about abysmal prison conditions, right? So literally just four separate reports have come out in that short time about different prisons overall, Young Offenders Institute, adult correctional facilities, all the rest of it, of just failing grades and all kinds of things. People being doubled up in cells which are barely good enough for one person, let alone two people. You know, record levels of violence between prisoners, record levels of violence between prisoners and staff, record levels of self-harm, high amounts of suicide. This is all just in the last couple of years, right?
yeah.
So it's so what does that say? And just constant promises from government and Ministry of Justice. Yes, this is very concerning. We'll look into this. This is of absolute importance. This is paramount. And then just very little gets done. So it's that also should be seen as the context of this, right? So it's important to note that really, while this vigil and this conversation is about Julian Assange and his bail application, but it is important to understand that it's not like everybody else is getting stellar treatment.
Oh,
You know what I mean?
you're absolutely right. Can I ask you? I don't know if you know the answer to this or not, but
Okay.
is there a precedent set where what the international law says overrules what English law says, or is that just applied as arbitrarily as it seems? Like,
But
how does that? What I'm probably saying this poorly. I've really only been awake for a little bit, and I'm undercaffeinated.
no, no, that's all right.
Um,
That's all right. It's a good, very
uh,
good question, by the way, because that comes up specifically in this case. That
okay,
is an important question.
I
And
mean,
international law has been raised repeatedly in this case, and it will continue to be so because extradition treaties are part of international law, right? They're treaties between two states. So and it's already been heavily cited, international law. So I'll put it this way. So from an international law perspective, right? The highest form of international law is binding on all states, right? From an international law perspective. So there's something called customary international law, which, despite its name, is in fact the most binding form of international law. So it is now considered is the Latin expression called jus cogent, if you don't pronounce the J. That is considered to be the most binding force of international law, which basically says that there are certain principles which are so ingrained now, part of international law, that even if you have not signed a treaty, they bind you. So they bind all countries, and any country which doesn't apply it is violating that principle. And by the way, this is a position that is officially accepted by America and Britain, and their legal teams argue it at the Supreme Security Council, and they argue it in the International Court of Justice when there are cases before the International Court of Justice. This isn't something that was made up by Mozambique, right? These are international legal principles that were heavily put forward by the main, most powerful countries in the world: Britain, France, the United States, China, Russia, right, over the last decades since the end of the Second World War. Now, despite that, there is a legal principle in this country that when international law and domestic British law conflict, domestic British law wins out. That is explicitly accepted by the courts here. So that if you have a conflict, an explicit conflict, right? So where international law will say, let's say, for example, international law does say that you cannot torture another human being, right? Under any circumstances, right? And let's say Parliament passes a law tomorrow that says under certain circumstances, you can do certain things that would normally be considered to be torture, including taking a blowtorch to somebody's face, right? According to judge-made law, according to the courts here, going back some time now, whatever Parliament says is supreme, even if it explicitly is contradicted by international law. That is settled law in this country. That's settled. That's not like up for debate. I may disagree with it. You may disagree with it. In fact, I do disagree with it. I've always disagreed with it. But that is from a British judge perspective, from a perspective of the judges. Obviously, if you're a judge of the International Court of Justice, you would disagree with that. But that's by the by. So actually, the point here is that when there is a contradiction or an explicit conflict, domestic law is considered to trump international law. And I can never say that word now since that man's become president without his face now sticking into my mind, something which I'm sure he's happy about. But that is a known expression here before Mr. Donald became president of the United States. But yeah, so that is the position basically, is they will say, okay, international law is important, but if there's a conflict, our law supersedes international law, even though, of course, Britain has played a key role in forming these international legal principles, right? So it's not, once again, it's not something completely alien. That's just one of the many contradictions. It's one thing that when I was speaking to German political representatives who were viewing his case, who were there sitting in with us in the press annex during the main hearings, that they found quite surprising, and other political representatives as well, because they're saying they when I was explaining to them, because the argument was being made in court where they were saying that British law trumps international law, so whatever international law says is secondary.
That
So
that
yeah,
is
that's that position.
that's a little disheartening to hear. I mean, what's the point of having international law and international precedents if they can just be pushed off to the side in terms of either expediency or because whatever the host country is has determined within their own right that international law will only apply when it's convenient for the state.
Well, I suppose the benefit would still be, okay, well, then Parliament still has to explicitly contradict, right, international law for it not to apply. You know what I mean? So there will be
Yeah.
plenty of situations where you could say, well, okay, but look, this is what these international treaties say, and even if, or this is what these international legal principles say, and there's no domestic law that contradicts it. So I put it to you, I respectfully submit to your ladyship or your lordship, as we say here, rather than your honor, that you should take these principles as heavily persuasive or even binding in certain cases. And in fact, in as Assange's case, where there is a dispute between an interpretation of the rules about the political exception, because that was a big key issue, was the political exception. The American lawyers, the lawyers for the U.S. government, were arguing that there is no political exception. And the British lawyers, or the Assange's lawyers, were saying, no, there is an exception, that if it's a political crime, you cannot extradite. And the disagreement was because in the treaty, the political exception, the exception for political crimes is there, the treaty, the Anglo-American treaty. but in the domestic legislation, it's not there. Now, what the defense lawyers were arguing is like, okay, but there's no contradiction because the treaty has it. Okay, Parliament saw fit to pass domestic legislation, an extradition law here without the but it's silent, and being silent is not the same thing as as explicitly saying we don't recognize a political exception. So literally that's the kind of thing that the decision will turn on, is an argument that they'll say, well, it's silent, so technically the treaty is still valid. um, but that is literally what it's like here. Whenever you're speaking to a judge, they will always be like, okay, where's the domestic legislation? Which, on a certain level makes perfect sense, because we exist in a world of nation states, and sovereignty from the perspective of these states, and is that domestic laws what should apply, and even though international law is formed by states, right, and through the actions of states. But yeah, let's be honest, part of this is just about power,
Oh,
right? It's about
for
power,
certain.
right? These are the most powerful countries, and obviously the most powerful countries will have the attitude that the laws apply to us when we say they apply to us. This is a point that was made to, Assange has an American lawyer who was also here during the main hearings, and I spoke to him, and I pointed, and we discussed this point in the United States, because in the U.S. Constitution, the U.S. Constitution explicitly states that the country will be bound by international law. I don't know how many people know this. I mean, it says it right there at the beginning. It says this country will be bound by the law of nations. And the law of nations is the old term. I mean, when I studied law, they still use that term, the law of nations. So it was the name of one of my books. The law of nations is just the old school term for public international law, right? But he said what happens is, whenever people try to raise an international legal principle, judges quite often will say you don't have standing to raise that as an individual, right? So you know what standing means? Standing just means whether or not you have the right. Yeah. So that's one way the courts can get around it, is to say, well, you just don't have standing to raise this particular international treaty. You don't have stand, or what have you. So it's the difference. A perfect example of the difference between theory and practice and the application of the law.
Okay. Um, Trying to think if there's any more questions I have. There's a bunch of stuff that I need to get to today. So the case management hearing is set for the 7th. Has the UK made any determination about what they're going to do with upcoming court cases? I know there was a statement made about uh if they thought it was going to take more than like 3 weeks, they weren't going to do it. Maybe I have that wrong. Maybe that's the
I
US.
thought it was 3 days.
Three
If a
days.
trial, if a jury trial, that's for jury trials. If a jury trial looks like it's going to take more than 3 days, and it will be scheduled for April or after, or no, up to April, then they should be adjourned, I think they said, for now. Um, Cases which have already been scheduled should be left alone on the basis that hopefully they can be completed. Um, they also said other mechanisms that can be used, like video link and what have you, whenever possible, should be taken advantage of. I didn't see, from those rules that you're referring to, I didn't see anything relating specifically for magistrate court cases. So jury trials are not held in the magistrates courts; they're
Right.
held in the high court, or in the like Central London Criminal Court or the Old Bailey or what have you. So those are separate. Those are cases on indictments. That's what the term indictment here means, by the way. If you have a jury,
Okay.
right? So those rules are specifically looking at that, but I imagine eventually of course, they're going to be looking at rules to deal with magistrate court cases as well. It's important to note that most cases are magistrate court cases. So most people don't get a jury,
Right.
right? You either get a single judge or you get three magistrates, which depending on whichever you think might be better, because at least magistrate, there's more than one person
Yeah.
deciding
Yeah.
the
Yeah.
fate.
Yeah.
But it's not guaranteed, and that's where most cases are. It's only if under certain circumstances, like if you face more than 12 months in prison, certain offenses are indictable only, like murder, I think rape, etc.
Okay. Okay. Yeah. I
Um,
mean, here we're, um, I guess, dissuaded from going through a jury trial simply because the process becomes so long, drawn out, and expensive. It's punitive to the defendant
yeah,
to pay legal fees and take the time either out of their life, either incarcerated waiting to go to trial or on house arrest. It's the system is designed solely to benefit the prosecution.
to
And
browbeat you. I was told that if 5% of people who are entitled to jury trials in the United States 5 or 10% actually requested their jury trials, the entire system would come to a standstill
yeah,
because it's so centered now around plea bargaining, and people, you either get 3 years if you plead guilty, or 25 years, or 15 years based on the way I'm prosecuting you. You don't have that here because there's no such thing as plea bargaining. You can't plea bargain here. But you do have a similar result, just sort of different means, similar result. Legal aid used to exist in this country. It's almost been abolished since austerity came in. Legal aid here is a bit different in the United States. Basically, legal aid meant that you could be a homeless person, but if you were charged with a serious enough offense, you could get a barrister like the one that Assange has of 20
mhm,
years experience, and it would be paid out of the public purse. But it would be paid at legal aid rates. So you have to understand that they're set fixed rates.
yeah,
The right, and so any lawyer, as long as they're on the list of being a legal aid lawyer, as willing to accept legal aid clients, could end up representing you. So you get the best lawyers in the country representing you at fixed rates. Yeah. Now, if you wanted, you could still choose to pay more to get specific lawyers and all the rest of it, of course, right?
yeah,
But so I was very impressed with that system when I came here. The fact that like that meant that like literally, like I said, you could be a homeless person, but if you were accused of like a very serious offense, you'd get a very qualified lawyer, right? And it would be paid for you, and you'd only pay if you felt it necessary, right? Well, that's pretty much gone out the window, right?
yeah.
Over the last 10 years. So legal aids have been almost all but abolished in most cases. Now you risk like losing your home if you're able to get a mortgage to pay your legal fees. That wasn't a thing before. For many, many years, possibly even decades, that wasn't a thing. You couldn't go bankrupt paying your legal fees. Now you can. Also, in terms of legal appeals, you used to get legal aid, you don't anymore. Certain types of cases that were deemed to be in the public interest to challenge the law, you could get legal aid for that. That's pretty much disappeared. Not 100%, but largely the number of cases now where people would get, because it's considered to be a serious, like assisted suicide, challenging the law. If it was
Mhm.
considered to be in the public interest, the legal aid board would give you funding so that you could challenge the law, things like that. So pretty much we are coming in line with your system, even if we don't have pre-bargaining. Like Assange, for example, there would have been a time he would have been entitled to legal aid for this case. He's not. He's having to raise the money,
Yeah, yeah, yeah.
right? 10 years ago, when I was in law school, he would have had the money from the legal aid board from the legal aid system to represent himself.
I
So it,
was
yeah.
for a personal anecdotal story. The last time that I had to go to court um, for breaking any series of laws, I was represented by a public defender, but my public defender was a Fourth Amendment specialist. Like that was his area of concentration for the law was our Fourth Amendment, which protects illegal search and seizure. Um, I was pulled over for driving while poor in a town called Saratoga, California, which is very, very, very high rent area, very exceedingly, astronomical property value area. I was in a mid 1990s Pontiac Grand Am, I believe. Uh, and yes, I pulled over for driving while poor. The car itself was a piece of shit. I was overheating. There was traffic on the freeway. I couldn't just sit there idling or my goddamn engine was going to explode. So I cut through this town, got pulled over. Within moments of me getting pulled over, there was the cop and his training officer, and then another cop, and then another cop, and then two more. And by the time it was all said and done,
Mm.
because I would not consent to a search of my vehicle, as is my right,
Yeah.
there were six cars, nine cops, and everybody had their hand on their gun.
Right.
Um, I knew that I had 3 pounds of cannabis in the trunk,
Yeah.
and I knew that it was going to a veterans collective to be donated.
Yeah.
Was planning on getting a receipt for that, as a matter
Yeah.
of fact. Um, but when we finally went to court over it because I didn't consent to a cinch, so they towed the car. As soon as the tow truck went up, that gave the police officers the quote unquote legal right to tear through the car. They find the
Essentially circumventing the Second Amendment. Is it?
yeah,
No, not Second Amendment. First
fourth,
Amendment.
yeah,
Fourth Amendment
Fourth Amendment,
on search procedures because they're saying
absolutely,
like you won't consent. Fine. Well, then we'll just tow it. So we'll take your property and then search it anyway. So
yeah,
it's a end run around the Fourth Amendment.
absolutely. And by the time that we went to court over it, um, the attorney that I had been appointed by the state or the county, I can't remember which specifically does the appointing in this case, uh, was like, "I have never seen a more blatant violation of your Fourth Amendment before in my life." By the way, I got the transcript from inside the officer's car, where the training officer specifically says, "Let's see what we can find." And the cop came back and was discussing, he's not letting me search the vehicle. I told him I would tow it, and he said, "Okay, I'll just take off," because that's what I said. "All right, I'm gonna fucking split for this. You guys have fun." Um, the training officer is on tape saying, "How can we unfuck this?" So by the time we went to court over it, the public defender that I had would just, he brought the cop up onto the stand. He asked him a couple of questions. The cop would lie on stand, and the lawyer said, "Okay, roll tape." And by the third time he said, "Okay, roll the tape," the initial judge that I was in front of was like, "You know what? I got to dismiss this case. This is ridiculous. I can't believe you guys were this incompetent and this unprofessional. Get the fuck out of my courtroom." Um, But in the process, I lost the car, I lost the 3 pounds of cannabis, I lost the phone that I had because they confiscated my phone. Um, and let's see, what else did I they were trying to charge me with, drug selling paraphernalia because the brown paper lunch bags I had for my children's school lunch were also in this car. And they wanted to give me a what was it? Drug production materials or some shit like that. They wanted to give me an ancillary charge for that.
And could you were you able to get any of this stuff back in the end, like the cannabis for the Veterans Association, your car, your phone?
I asked the lawyer if I should, and he was like, "You know what, dude? You might as well just let sleeping dogs lie on this. You're probably not going to get your cannabis back. You were over your legal limit. You're supposed to have, yeah, I could have 2 pounds. I had three.
Okay.
Um,
What
uh,
about the car and the phone?
the car itself was a I think it was a free car or like a $500 car or something like that. Like we it was our secondary mode of transportation, but important all the
Consider it to
same.
be a write-off or
Yeah, yeah. It's what the whole thing was basically a giant loss. Um, I did have to come up with some cash to pay back the initial cost of the cannabis because it wasn't mine that I grew. I was just
hmm.
going and I was
And then what
transporting.
about the legal fees? The le
So, because the case got dismissed in my favor, I think I only had to pay like a $75 court cost for making people show up. I didn't have to pay any attorney fees. I didn't have to pay, yeah, that's all I did. I just had to pay like a $75 court cost. and that was it.
That is interesting, that isn't it? Because I've noticed that more and more in the UK is just these ever increasing fees. And the idea of having to pay a court cost. So the state, right? The state is taking you to court, but you have to pay court costs. So that, once again, that's something that as we some of these things were recently introduced in this country. Some of them I think have reappeared after many, many years, after being abolished for many years because they're deemed unfair to the poor. And of course, what does it say when things were abolished like 50 years ago or 60 years ago, 80 years ago, and slowly start creeping back in? But even the idea, so like right now, I could imagine after that kind of nightmare, you'd gladly pay the 75 bucks. Be like, wow, I got off lucky. But why
Yeah.
should you be paying anything? Why should you be paying a court fee for having what, the temerity to defend you, to plead not guilty when you're arrested?
Right, right. No, you're absolutely right, and the system as it stands here in the US is designed to, increase the amount of recidivism in the court system because they will give, lots and lots of fines and court fees and whatnot,
And you can't
and
pay it off, so you get dragged back in. You can be used as free labor in the prison system, and then more fines that you then have to
absolutely.
pay, and then they just pile up. It's like a bank, a predatory bank, except it's not the bank; it's the local government doing it.
Yeah, and it keeps, I don't know if the UK has private prisons, about 6 or 7% of the prisons in the US are privately owned and operated, and they have, a contract with individual states for funding. If they don't have X amount of beds full, they don't receive their federal subsidies, so then they have to shut down. So it benefits the court system to keep the people like to go after private prisons here. I always make the argument that if you shut down every private prison in the US, we would still have, 94% of existing prisons. And
Yeah,
while it's important to do that, it's, barely a dent in the system. But it is an
perverse
exceptional
incentives.
moneymaker for the
Yeah,
state.
yeah, those are perverse. Yeah, because what ends up happening is that you end up having additional economic incentives to further entrench sort of policies which are already negative in their nature. We have private prisons here, and that their operation is run. But not just that, even not just the prisons, even the security people who were in charge of securing Julian Assange, right? When they take him, when he's taken out of prison to court and back, or when during the main hearings in February, the people there in the dock with him, overseeing him, are a private security firm known as Serco. It's actually Serco is a massive conglomerate. They provide all kinds of, you know, services to immigration, like criminal justice issues, as well as health and transportation. And it's one of these giant sort of monstrosities that provide services in all kinds of different fields. And prison, the home office related matters is just one of them. So yeah, it's what it is here. Privatization is quite often in the form of there's two main forms, right? One where something is completely sold off and is completely a private business, like a British Petroleum, right? So that used to be state owned, right? There are loads of things which are British Telecom, BT, right? Used to be nationalized. British Airways, right? Used to be completely state owned. There are loads of things that were just sold off, right? During the fire sale of Thatcher and beyond, and then on labor. But others which are privatized in the sense of outsourcing. So instead of it being public organization, it's a private organization which will deliver certain parts of the services. So there's a private company which does the transcription. So you have to pay a private company if you want to get the court transcripts, right? You can't do it yourself. You can't get a recording and do it yourself. The recording goes straight to a private company. A private company provides security in certain aspects. A company might do the transportation of certain goods. A private company might do the laundry or the catering and things like that. So more and more aspects of certain public services get privatized, and that private companies tender and then get the contracts and then get to make a profit on off of it. But it also means that things are just so poorly managed, right? Because you have so many different organizations with different ways of doing things. And of course, it's more expensive in the long run. And staff tend to be treated worse because where do you make your money? By paying people worse, less, right? It's
Yeah,
labor is
yeah, yeah.
where you know, the more you pay your staff, the more, human beings are paid, the less profit there is for an organization. So and that's how the private prison situation is here. It's prisons are privately managed and run by different companies rather than I don't know if they necessarily completely own and operate. I don't think we have the contracts unless they're secret contracts. I don't think they exist the way you have them in a state where you have to ensure 95% capacity or you violate
Yeah. Yeah, yeah.
so we're not yet at that level. But the problem is here anyway, they wouldn't need that contract because we're bursting at the seams with our prisons. There are too many people. They're at capacity or beyond capacity anyway. And there are prisons that should have been shut down and demolished years ago that are still operating. So is it when you go into some of these places, they're quite medieval. Like,
Oh yeah.
you look at them and you think like, when were these things built, and what were they built for? One of them was a former mental asylum turned prison. I can't imagine being in it when it was a mental asylum. Let alone being in prison. Sometimes you look at them and you think, honestly. So it's
Yeah, no, it's the state of prisons, I'm pretty sure globally it is they're all, in disrepair. They're all uh just petri dishes for disease. Um Rikers Island in New York gets a lot of press for being completely debilitated and just, falling apart and being one of the worst prisons. But we've got San Quentin here, we've got Folsom here. They're in huge states of disrepair. Right before this virus took over 99% of the news, they
Mhm,
were finally starting to run stories about all of the inmate murders that were taking place in a Mississippi prison, in one particular Mississippi prison.
mhm.
Now that's completely gone out of the news, and that prison is allowed to operate as they were operating. Real quick, Rob Juno, thank you for the super chat. I will absolutely have Mo back. Um, I'm going to go ahead and wrap now because I
Cool.
do have a lot more to get to later and I have to take some time out to get some chores done around the house. But I want to thank you very much, Mo, for coming on the show. I always try to get primary source accounts when this happens. And I appreciate the fact that you are able to get into the courtroom as often as you are, and that you do have the legal background to not overly emotionalize what was
Mm.
happening. Please tell the folks where they can find your work. And yes, please come back to the show.
Okay, yeah, thank you very much for having me. You guys do great work. I'm impressed with how consistently you have your video broadcasts. People can follow me on Twitter, which is just my first initial of my first name, which is M for Mohammed, and then my last name, which is El Mazi. That's at M El Mazi. And then you can see the various places that I publish with on my Twitter profile, primarily with Sputnik International, but also the Canary. I have my own blog, which is the interregnum.net, and there'll be some others. And I generally speaking, if there's something that I think that I've written that I don't think is like terrible, I'll tweet it out so people can just follow me on Twitter.
I was on about a 2+ hour live stream with Gordon Dimmick yesterday, and
Oh yeah, I know
he
Gordon.
he made sure to give you a shout out
Did
to
he?
his audience. Um, that was a wild show, by the way. Gordon was uh, Gordon was getting nice and tuned up during the process. We we
Oh,
we
was
covered
he?
and it, we covered a lot of ground. Um, but yeah, so thank you very much, Mo. To the folks that are listening, thank you for being here. Thank you for being a part of this with me. I know there's a lot of other people that are live streaming right now, so I really do appreciate the time that you've dedicated to this. Thank you, Rob Juno, for the super chat. That's going to do it for me. My
Okay.
name is Steve Poikinen. This has been Slow News Day.